So this is Utah v. Streif. It is a 2016 Supreme Court decision. It's on the Attenuation Doctrine, and the reason why I'm bringing it up is because, well, we'll see. So in this particular case, Streif was seen coming out of a suspected drug house. The officer followed him to a nearby convenience store where he detained Streif and demanded Streif's identification, which under Utah law, Streif was obligated to provide the officer. And okay, so it's kind of it's weird. So remember that the officer needs reasonable suspicion to demand the name, address, etc. So he needs reasonable suspicion of a crime in order to demand the ID. So he demanded the ID. Streif handed it over. There was a background check where it turned up an arrest warrant, and so he arrested Streif for the arrest warrant, searched Streif, and discovered meth and drug paraphernalia. Now, obviously, Streif doesn't want to go to prison for meth and drug paraphernalia, etc., and so he looked to suppress everything. Obviously, you want to suppress the finding of that arrest warrant because the officer didn't have reasonable suspicion to detain him. You also want to suppress the meth and the drug paraphernalia because, again, the officer didn't have reason to detain him. Well, so the court went through the attenuation doctrine in here, and there's three factors. The first factor is the temporal proximity. It's how close in time the the Fourth Amendment violation is to when they actually find the evidence that the defense wants to suppress. In this case, it was about a minute. So that favored the defendant. The second factor is the presence of intervening circumstances, in which this intervening circumstance is the existence of the warrant. The warrant predated the unlawful detention, and it wasn't, there was nothing about the unlawful detention that tainted the warrant, so that favors everything being not suppressed. And the third factor is the good boy didn't do nothing factor. I mean, it's the purpose and flagrancy of the official misconduct, in which the officer made two good faith mistakes. These weren't bad faith mistakes. These were good faith mistakes. He just wasn't trained properly. He hadn't observed the time that Streif entered the drug house, so he didn't know how long Streif had been there. He lacked a sufficient basis to conclude that Streif was a short-term visitor who may have been consummating a drug transaction. And because he lacked that, he should have asked Streif whether he could speak to him instead of demanding Streif do so. So he didn't have a reasonable suspicion to make the detention. And because he didn't have reasonable suspicion to make the detention, he should have asked Streif. But if he just asked Streif, he wouldn't have got the ID, because if he didn't have reasonable suspicion to make a detention, he didn't have the right to demand the ID. It's a terrible decision. I hate this decision. Anyway, so in order to get reasonable suspicion, this is Illinois v. Wardlow. Brrr, another Supreme Court decision. One I actually like. I think this one was well reasoned, if not really. I mean, I think it was well reasoned. I think it gives people a good guideline into what to look for. But this is old stuff from it. This is just quoting Terry, basically. The officer must be able to articulate more than an inchoate and unparticularized suspicion or hunch of criminal activity. And if you look at all these cases, they have a strong suspicion that what the person they were detaining was doing was actually criminal. So Terry, they suspected, Terry was suspected of getting ready, casing places to commit armed robbery. And obviously, if you're going to commit armed robbery, you're going to be armed. Bada boom, bada bing. It all made sense. Illinois v. Wardlow, they went into a high crime or a high incident of narcotics trafficking area. The guy ran. He saw them and ran. They saw him, see him, and ran. He was holding a bag. They detained him. With dealing drugs comes a high probability of being armed. So they did the Terry frisk on him, and there was a gun. So that all made sense. None of these were like, hey, show me your license so I can figure out if you're committing a crime. Whereas this one was, show me your license so I can figure out if you're committing a crime. I think it was terrible. But what Streif did is it basically allowed cops to play stupid, to make detentions that are unsupported by reasonable suspicion, and fish for that ID. If they can get the ID, then they can figure out if you got a warrant, and then if you got a warrant, all bets are off. Or maybe they can put you together with something like, oh, you know, maybe you have a restraining order, maybe you have something in your record that keeps you from going to out, like if you're on some court-ordered alcohol rehabilitation thing, you're not supposed to be near liquor stores or something like that. Maybe they're looking for a reason that's not actually what they stopped you for to arrest you, is basically the deal. With all that in mind, I found this video from Dr. Manhattan. It was published 4 days ago, and it was very interesting. The background is Dr. Manhattan was in a public park in San Francisco. California does not have this type of statute where they can demand your ID if they've detained you. So he was in a public park, which is a traditional public forum, and somebody said that he was filming the security gate into San Francisco airport, which is not a crime. Police recalled this police officer came out and detained him and asked for about 15 minutes for his ID. But let's listen to about 20 seconds of it and pray that we don't get a copyright strike.
That's all I'm trying to do is determine whether or not a crime has occurred. By providing me your ID, we could end this very quickly. As long as you're not wanted,
but did I commit a crime?
Any type of other suspicious group, then you'll be on your way.
I'm trying to figure out if a crime has been committed. So if you just give me your ID, this all can be over quickly. I just need to know if you have a warrant or if you're tied to any other suspicious group. Number one, what's a suspicious group? I am assuming this officer is just retarded and thinking like terrorist group, not suspicious group. That's a punchable face if I ever saw one. Anyway, so I'm assuming this officer is just being retarded and doesn't know exactly how to say terrorist group, or is trying to soft shoe around it. But it's very indicative that he's not looking to actually investigate what Dr. Manhattan did as a crime. Because again, Dr. Manhattan was in a public park. When the park was open, it's daytime. Parks are typically open, at least the ones that I've seen. I've been to San Francisco. They're typically open from sunrise to sunset. And so, I mean, every indicia that Dr. Manhattan should be legally allowed to be there. It's a traditional public forum, so there's every indicia that Dr. Manhattan should be allowed to film there. The gate to the airport is visible from a public spot, so he should be able to film it. So it would be interesting to know what crime this chowderhead thought that he could maybe pin on Dr. Manhattan. But again, it's just like in Utah v. Streif. He's looking for that soft way around the Fourth Amendment. He's looking to violate Dr. Manhattan's rights by unlawfully detaining him because he does not, he doesn't have reasonable suspicion, because eventually Dr. Manhattan gets tired of the shenanigans and decides that he's going to walk, and this guy plays lost puppy and just follows after him because he knows that he doesn't have reasonable suspicion for the detention. So he's doing an unlawful detention, he's fishing for that driver's license, and then he's going to play I didn't do nothing when he gets into court. Oh, it was a good faith mistake. I thought there was something under the Terrorism Act or whatever that allowed me to do this. Anyway, I just bringing this up to your attention so that maybe you can stay a little safer out there while you're on audits. Talk to a lawyer, see if you are required to ID and in what circumstances, and stay safe.